Hi everyone, my name is James. I'm a law student at QUT and I've been given the task to explain when a shape can be registered as a trademark, specifically with reference to the following two cases. I'll reference the cases as a Kenman case and Phillips case respectively, as they appear on screen. A trademark is defined as a sign under Section 17 of the Trademarks Act 1995. Section 6 of the same Act defines a sign as including shapes, and this takes its natural meaning as reiterated by Justice Lehane J. as including the shapes of goods or parts thereof. Justice Lehane J. also made it clear with reference to the Coca-Cola case as a precedent that a trademark must be distinguishable from those of the goods it is attached to, or to in relation to which it is used. In this case, the applicants were Philips Electronics Australia Limited, who had applied to the Trademark Registrar for their triple-head rotary shavers to be registered Class A for shaving apparatus. On the other hand, in June 1997, Remington Products Australia Proprietary Limited imported and intended to sell a triple-headed rotary shaver. Justice Lehane J. considered the extent to which Philips Electronics trademark was protected in relation to Remington's seemingly similar shape of a three-headed rotary shaver. The Working Party report was considered and illustrated that there was a majority support for applicants that want to register trademarks to show that the trademark does not result from the nature of the product. As Philips registration was considered to be of the nature of the product itself, Sections 41, subsection 6 of the Trademarks Act applied. With this section, the senior counsel for Philips Electronics argued that their company was the first in Australia to be selling the three-headed rotary shaver design, and the marketing and advertisement was thus a powerful image to consumers. However, Justice Lehane J. had concluded that Remington's product had not been a fraudulent imitation, or simply a disguised copy because the size and weight of the product had been impacted by imperative mechanical components during the manufacturing process, which included waterproofing. Shapes that are essential components of a technical result, such as the manufacturing process for rotary shavers, would not be construed as being distinguishable as a trademark. Secondly, the Kenman case considers the registration of an animal-like shape, the Millennium Bug, by Kenman Kandy Australia Proprietary Limited, who disputes the initial decision of the Registrar of Trademarks for rejecting their application. Justice French J., who was in the majority, concluded that the previous judge had erred in considering the inherent adaptability of the Millennium Bug. According to Justice French J., the Millennium Bug was a concocted shape resembling a variety of insects capable of being inherently adapted to distinguish Kenman Kandy's confectionery from others. Dissenting was Justice Lingren J., who sympathised with the Registrar's initial decision to not allow the registration of the Millennium Bug, hence avoiding restrictions of using the greater common of shapes. It was argued that it would restrict all traders in the use of common shapes, such as the shape of a sheep as a confectionery chocolate. This is known as the notion of fencing in the common. However, Justice Stone J. had agreed with Justice French J. in the decision that fencing in the common did not occur, as the Millennium Bug was an entirely concocted shape and, despite having a resemblance of a variety of real insects, would not lead other traders into confusion of the trademark with a single commonly known insect. In conclusion, the judgments of both cases had decided that for shapes to be registered as a trademark there are a few ground rules, as illustrated behind me, especially avoiding fencing in the common, as we saw in Kenman's case, whereas if the Millennium Bug were to be a commonly known insect, it probably wouldn't have been registerable. I hope this was helpful, and thank you. Have a great day.